Well, thank you, Torin,
Yeah.
and Stephen and Andy, who are also sort of navigating this system for you. Thanks for inviting me. I really appreciate it. And I am going to talk to you, yes, today, hopefully to start a conversation. I'm going to talk about a research project that I led while I was at NLADA that examined one specific type of criminal legal system fee, and that's public defense system fees. So just to be clear, I'm not talking about other types of fees or about fines. In criminal cases, fines are a form of punishment that are imposed to hold people accountable for violating the law. And fees are a mechanism to raise money that's used to pay for government services, and it's regardless of anyone's guilt. So, this will cooperate. There you go. People charged with crimes face a multitude of fees. This is a sentencing sheet from a county in Oklahoma, and it has checkoffs a judge can complete for 29 possible fees plus a fine. And you see fees for daily jail costs and warrants and forensic testing and prosecution and jury trials, probation supervision, just so much. All but one of those are assessed on everyone who is criminally adjudicated. Number 29, attorney fees, you can see that, is only assessed on people who exercise their constitutional right to have counsel appointed at government expense. And people, of course, exercise that right because they can't afford to hire a lawyer. So that's right. People who can't afford a lawyer are entitled to have one appointed, but then they get charged for that. And not surprisingly, people can't always pay these fees, and that's where the problems arise. So NLADA looked into public defense system fees in the adult criminal system to shed light on, first of all, how pervasive these fees are, and second of all, what impacts they have. And the goal of the project was to document the scope of the problem nationally, and to make that information available for states to use in local reform efforts to eliminate or reform use of the fees. And there are two types of public defense system fees that we looked at. The first is application or administrative fees, and these are assessed at the outset of a case when eligibility is determined. And the second are cost of counsel or reimbursement or recoupment fees. They have different names, but they're all the same thing, recoupment. And that's assessed at disposition. And laws permitting recoupment have been in use really since the Gideon opinion was issued. Upfront application fees they really multiplied in the 1990s as more and more court user fees were being created to offset the ballooning costs of our criminal legal system. And so you may wonder, why bother with all of this research? These fees, they feel unconstitutional, like they violate the right to counsel or due process or equal protection rights. Unfortunately, legal challenges have been largely unsuccessful. Two Supreme Court cases sort of summarize where the government's position at this point. In Fuller versus Oregon, which challenged recoupment, the court held that, first of all, states have a legitimate interest in recouping the cost of counsel. And second, that the right to counsel isn't affected because counsel is appointed, and then just being asked to pay for it after that in the future doesn't affect that. And third, if payment poses a manifest hardship, then individuals won't have to pay. The other case is Bearden versus Georgia, which involved a challenge to imposition of a fine, and that's been extended to apply to fees. Bearden prohibits detention of someone over failure to pay a fine or a fee before a court has determined whether that failure to pay was willful. So those really don't sound that bad, but the problem is with both Fuller and Bearden that it lies with the actual practices of our criminal legal systems. And too many fail to truly assess ability to pay in a meaningful fashion, and some still arrest and detain people for failure to make a payment toward court debt without first holding an inquiry into whether that non-payment was willful or simply an impossibility due to shortage of funds. So we went ahead and did the research. The methodology was a two-part methodology. The first was a 50-state statute search, and the second was deep dive looks into several states. And the statute questions, 50 state statutes search, looked at 5 questions. First, is there authorization for assessment of upfront fees? Second, is there authorization for recoupment? Third, we wanted to know how indigency is determined. Is that by the judge or by the public defender or by some other means? Fourth, because many people who are assessed these fees are put on payment plans to pay them down. We wanted to know if payment of public defense system fees was a condition of probation, so non-payment that can then trigger a probation violation. And then finally, we wanted to know, does fee revenue from these fees directly fund the indigent defense system? And in the deep dives, what we looked at, we looked at 4 states. And these were done to gain insight into practice that statute review alone can't tell you. And this was all qualitative work with review and analysis of materials and interviews with dozens of people, including public defenders, and contract defenders, and judges, and clerks, and advocates, and impacted people. And we selected states for different reasons, including sort of the severity of the fees or access to data. And these are the 4 states. Oklahoma has both fees. It has for the Oklahoma Indigent Defense System, which is the state system in 75 of the 77 counties. There's both an upfront $40 application fee, and there is a flat fee assessed in cases where people are adjudicated guilty of $150 in a misdemeanor guilty plea, $250 in a felony guilty plea. And if you go to jury trial, those fees are higher than that. Iowa does not have a upfront fee, but it does have recoupment, and it can be some of the highest in the country because you're on the hook for the total cost of counsel. And even though attorneys, earn the princely sums of $66 to $76 an hour, that can really add up to sometimes $10,000 or more, thousands of dollars. We looked at Clark County, Nevada, where they have, again, no upfront fee, and they have a counsel fee that varies. It's up to the judge, but they kind of land on that $150 misdemeanor, $250 felony scheme. And then New Hampshire, we looked at, they don't have an upfront fee, they have recoupment. And we selected New Hampshire because it has surprisingly good data on the cost to administer its recoupment system. It actually has an office called the Office of Cost Containment dedicated solely to this task. So here's some of the findings from the statute search. At the time we finished our research, 18 states had upfront fees, 42 states and the District of Columbia had recoupment fees, and 17 states you could be authorized assess both of those fees. There were 7 states that had no public defense system fees, and 30 states made payment of your fees a condition of probation. And 24 states directed some of the money or all of it, revenue from these fees, to the public defense system. Now, we finished our research in July, and there has been a little bit of progress, which is great. Delaware repealed its $100 public defense administrative fee. And so the red numbers reflect where we really stand right now. For the deep dives, we have a very lengthy report, and you certainly can pour through it to see all of the findings that we came across. So I'm just going to select a few to talk about. First of all, there are very serious consequences to individuals for failure to pay in full or on time. And these include warrant, arrest, and detention to answer for failure to pay or for failure to appear and explain why you haven't paid a fee. There can be judicial garnishment by a prosecutor. There can be administrative garnishment by Department of Revenue. You can have your offset, you can have your tax refunds offset or your benefits offset, pay these fees. You can be referred to a private collection agency. You can be denied the ability to renew your car registration. Your driver's license can be suspended. You can have your professional license suspended. You can be denied expungement. You can be, your supervised release might be revoked, and you could be held in contempt of court. And we saw that people have to make hard decisions about whether to pay the fees owed. or to pay things like rent or utilities, or to buy groceries. Public defenders told us that clients resort to sex work, sell drugs, do other illegal acts to get the money sometimes. And they also said that they see that consequences of court debt can affect people much longer than some carceral sentences. So next, we found there were extremely low rates of collection of these fees. The data in this area is very slipshod, but in no state where data on assessment and collection of public defense system fees were available did collection amount to more than 5% of what was assessed. There are also non-negligible administrative costs to pursue debt that eat into these low returns. For example, in Oklahoma, they have something called cost dockets. These are held solely to monitor compliance with court debt repayment. And there are costs to staff cost dockets with a judge, a clerk, a prosecutor, a bailiff, a defense counsel, etc. And this is all maybe to net $25 from an individual. It's pretty crazy. Also, fees perpetuate a two-tier justice system. People don't receive equal protection under the law when their financial resources drive outcomes. If you hire a private attorney and you fail to pay her, you might face a civil lawsuit from that lawyer, but you're not going to face arrest or detention or the prospect of additional punitive sanctions like prolonged probation. Also, you're not going to be prevented from seeking record expungement if you have no court debt. And so another thing was that, as I said, the deep dives yield insight into practice that you really can't get from the statute review. And examples of that are, one, laws require determination of ability to pay be done before imposing fees. But we found it often is not done, or it's not done using measures that take into actual cost of living. They don't count for actual cost of living. In Oklahoma, the $40 upfront fee itself can be burdensome, but even worse we found was the application process. That can cause a week or weeks long delay in actually appointing counsel because of the process. So basically you come in for initial appearance if you're out on bond and you're seeking counsel and you're told to go out and collect the names of 3 attorneys who say that I can't represent you because you can't afford it, and bring that back to court. If you happen to be out on bond and a family member or a friend helped you pay for it, you might have to get an affidavit from them attesting that they're not able to also pay for your counsel. And you have to collect all of that. No legal counsel is appointed until all this material is gathered and brought back to the judge at a later court date. And that can be weeks sometimes. We found that defenders don't always advocate for fee reduction or fee waiver. And there were different reasons for this. Sometimes they're not trained to do it. Sometimes the culture doesn't emphasize the importance of that. They feel the judge will disfavor it, maybe. Or sometimes they don't even know what the total cost of the fees is going to be at the time of sentencing, which is when their role in the case ends. So they really can't meaningfully advocate for reduction or waiver then. And then finally, we see totally different results in similarly situated cases. So from court to court, from judge to judge, from county to county, this is all up to the judge's discretion for the most part, and it underscores the inequity of these fees. So what else? With any research project, there's always more work to be done. And here we need substantially more effort put into collecting and shining light on data about assessments and collections. These laws exist, but many lawmakers don't really know how little is collected or how much harm is done to individuals from this court debt burden. And we need data on, are people waiving counsel because they don't want to incur the expense? I know that CCI is doing some work in this area, so I really looking forward to what they learn. And then we need much more information from directly impacted people. All of our deep dive work was conducted during COVID travel restriction time, so we did it remotely. We weren't on site, and that really affected our ability to talk to interview directly impacted people, which is sometimes easier to do when you're in court for court observation, catch people at court, or to meet with community organizations. We need their stories about whether people forgo counsel forgo appointment of counsel because they don't want to have that debt. We need to know if people's individual experience on their ability to pay determinations. We need to just know more about the effects of owing these fees on people's ability to move forward in life, and more. So advocates are key to this. One thing we saw in Virginia, the Legal Aid Justice Center has held public listening sessions with impacted people about fees, and they got an earful in particular about counsel fees. So that's a necessary path. Yeah, so most likely these fees are going to change because of legislative changes, not litigation. Research has to be paired with action, and action and advocacy are the key to this, I think. And we have seen that research and advocacy in California resulted in an elimination of public defense system and other administrative fees in the juvenile and adult criminal systems. I want to close by acknowledging that all types of fees affect poor people, and they disproportionately affect Black and brown people who are overrepresented in the criminal legal system. We really want to eliminate all of these fees. However, that's difficult. And I think that shining a spotlight on this specific category of public defense fees specifically might hold promise forward to some of these broader reform efforts. When I tell friends and family that people who receive court-appointed counsel are very often then asked to pay for it, they react in two ways. First, they didn't know that. And second of all, they just have a gut reaction that just seems unfair. And I think that suggests possible approaches. There's in Oklahoma, for instance, there's been some movement forward for a reform of criminal legal system fees, not the counsel fees. And so when I was putting together notes for this presentation for the ASC conference back in November, I wanted to see if any efforts have been launched to address counsel fees since July, since we finished our research. And one former legislator in Oklahoma, who's now in private practice, told me what you see here on this slide. He said, I don't recall there ever being a discussion regarding elimination of the OIDS fee application or the OIDS counsel fee. With that said, I think that might be a criminal justice proposal that wouldn't face the same type of uphill battle. And I find that really encouraging. And I hope that it's encouraging for others who are concerned about this issue. He said he would put out feelers with his former colleagues, and there's a door open. So yeah, there's much more in our reports, findings from this activity. It's an 18-month-long investigation. The website here has not just the report, but it also has this series of interactive maps for the statute questions. Yeah, so the next steps are that we hope that the word gets used in places like Virginia and Oklahoma and Vermont, which stood out as some states, but it looks like there's a movement for reform that could be successful. We've got allies like the Fines and Fees Justice Center working on this that can help. Yeah, and that's about all I have. I appreciate you listening, and I really hope that we hear from other people who are working on similar fees issues. And I will.
Thank you very much, Marea. So we will open the floor now. Feel free to unmute or show your camera. And if you have a question or just a topic that you want to bring up, you can also drop it in the chat, and I'm happy to read it out if for whatever reason you're unwilling or unable to use your microphone. I'll let it pause for a second to see if anyone wants to go. Otherwise, I have things to say. Okay, so I know this is kind of out of scope for the project that you guys did, Marea. But as someone who's a researcher who's like never really been in a courtroom, I mean, I've been very occasionally, but not in any kind of practicing courtroom. But I'm kind of unfamiliar with the judicial decision making here. I know in Indiana, from what people have said, so I know we have a $50 public defense fee that most people pay, but then it can go all the way up to the entire cost of representation, depending on essentially like not even justice by geography, but justice by judge. And I'm sure that you essentially alluded to that yourself, Maria, that that's not an uncommon thing in many states. But I wonder, like, do the judges see this as a punishment, or do they realize that they're not going to recoup most of this money? I'm not like it seems like such an obviously counterproductive thing to do, but I wonder if it's just kind of like a like, this is what justice should be. Like, you got this representation and therefore you should have to pay for it or pay some amount for it. So I'm curious if you, Maria, have any thoughts, or if anyone who has kind of practiced in this area and seen these decisions can lend any insight into what the judges' thoughts are, and if they would oppose these reforms, that kind of thing.
That is a really good question. I hope that other people can chime in on this. What we found was that judges, it just is up to the judge. All of this is discretion. Most of this is discretionary. So it's up to the judge's individual sort of worldview to a large extent, up to their biases, up to their what they think is appropriate. And sometimes there can be a conflict that some of these fees fund the courts. So potentially that may be a factor. They may be getting pressured to make sure that they're, it depends on the state, that they're bringing in their fees and their fine revenue. But yes, it's very much judge by judge, and it is completely uneven and completely unfair, but from where you happen to be appearing, you're going to have a different result. And that's Indiana has both an upfront fee and a cost of counsel fee, and they're not insignificant. They are, I think the judges kind of think, well, it's just $50. What's that? And that is a lot to some people. So I just don't think there's this understanding from a lot of judges too about what it is that people are, facing. I guess it's not just the defense counsel fee; it's all of the fines and fees in particular, and fees and fines. Yeah, I don't know if that answers your question, but other people might have reactions to that.
So Zach in chat says it varies with all the judges I've practiced before. In most courts, the court reporter or court staff do the paperwork. So that is almost, it's kind of a non-decision on the part of the judge, right? I imagine there's just kind of a standard thing that they do, and then that's what happens.
That's true. Like, sometimes you're just not involved at all. It's like, oh, go down to the hall and go talk to the cost administrators. What the Oklahoma judges will say to people, they aren't even necessarily, they'll tick off the things on that sentencing sheet that you saw, then they'll leave it up to the court administrators to go figure out how to administer it, what your payment plan should be per month, what it's kind of like, it depends on the state entirely. They have different systems, but it just varies wildly.
I know. Go ahead.
Somebody put the link up to their report. I appreciate that, because I know what I might. But,
yeah, there's a ton of detail in that report. So I definitely recommend anyone to go check it out. I know we had an issue that, as far as I know, is no longer being done, but there was at least one court in Indiana where not only they were collecting the usual fees, but then they would make, if you took a plea agreement, you would have to, part of that plea agreement would be required to be by that judge that you let them recoup all of the costs of your defense. So that was like a requirement for plea. And then they were also getting reimbursement from the state. So they were actually generating money off of the public defense in their court. So it's crazy to me the degree to which that discretion is there, and it seems like the statutes in Indiana are kind of written to be like that vague and interpretable, such that it makes it very difficult for the defense to advocate, because they don't have much to point to. There's kind of like a couple statutes, one that mentions the $50 thing, and then one that says it can kind of be up to a certain up to the amount of the entirety of the defense. So I do think it is a big problem in Indiana, and if nothing else, it needs to be standardized, just so that there's something that that defense counsel can point to, at least have a voice.
Yeah, I really agree with it. Meg, you unmuted, so I don't.
Yeah, I mean, I'm just trying to think, like, I don't think there's anyone really on this call probably that's like, yay, let's charge people for their defense counsel. So clearly, like, that's done. So my question is sort of like, what I'm thinking about is what could we do? Like, what are the best ways to sort of attack this? And obviously with the Oklahoma legislator, that's promising that he doesn't, I think once people think about it, yeah, that's right. And so from my point of view, like any cost benefit stuff, would be good. I think that's sort of what I'm thinking is like, how do we get more data on sort of the recruitment? You said that only one state had good data on that. And is that at a state level? And then like each other place, it's like more county level?
So there's New Hampshire just is weird because it has that. At first I thought that sounds awful. They have an Office of Cost Containment that just, but it also has, access to data, which is not the case in the other states that don't have that.
Right.
And so that's a benefit, but yeah, there's no requirement that's uniform to track this information, which I think is critical. So that's like a key thing. First of all, they need to have to be able to track it and explain what they're doing to justify having it. I think it's just like bad government.
Yeah.
The standardization too. Well, there is a report by, I think, the ACLU that found that it costs like $1.40 to go after every dollar or something like that. Like there's a net. There is some economic analysis out there. And it varies very much from state to state because some courts are super aggressive about actually this stuff. And some are just like, like in Vermont, it's kind of everybody's kind of agreed that they're not really going to make a priority of this. That to me is low hanging fruit. You go after that because there can be judges in certain parts of the state. As we said, it's all up to individual judges that decide, well, I'm going to be that one guy that says you need to pay this, well, that's not fair to people. So that's one that I would say that's low hanging fruit. Go after that in an advocacy kind of approach. Probably doesn't need litigation at all. It's just there. But it's also intertwined with the ability to pay problems and the indigenous determination problems because they're all intertwined. And it's like if you can do work around eliminating how these things actually play out in person, I think that would be very valuable for legislators to hear because they don't understand how it works necessarily. And just the community, you need to get the community involved with these things because it's the community where the harm is felt. It really affects individuals' ability to move forward. Well, I don't know.
Oh yeah, no, I completely agree.
So one of the things that I think Indiana does decently well is that the money that gets recouped goes towards public defense in some way or another. In fact, part of our agency's budget is those public defense fees. So it is somewhat of a conflict of interest for us. But I wonder if you think that's useful in terms of, because it happens at the local level as well. Not all of it goes up to the state. A lot of it stays local. In fact, I think most of it stays local. But it goes in to fund public defense. But I do wonder if then the court budget just kind of shrinks away and they're essentially recouping it for the court, even though by statute it goes into the specific fund that goes towards public defense. But that just means the court has to pay less for public defense. Is that has that been at all useful for any of the jurisdictions that kind of impose that rule as like kind of a keeping people honest system, or is it all kind of a shell game?
It cuts multiple ways because it's really it is a conflict of interest for defenders to be, particularly when people are only assessed these fees when they're adjudicated guilty. Well, that's a little bit of, tough spot for a defender agency that relies on that. Do they want their clients to be adjudicated guilty? Of course not, but that is helping fund them. So that's the case in some places. In others, like Oklahoma in particular, they have been able to quantify how much they're bringing in. It's, it's non-negligible in terms of it's maybe 2% of their overall budget, which they need. That's something that they rely on. They can't get rid of it. So we're just suggesting that, as in California, if there are any efforts to eliminate these fees that specifically fund the indigent defense system itself, that money has to be replaced through general fund appropriation. And in California, they went back, they backfilled all of the revenue that the counties would be losing, so to speak, from all the fees that they eliminated. So that was like, that's the best approach, because otherwise you're harming the counties when it's a county by county system. So really, I mean, ultimately, indigent defense is a state responsibility that it sometimes passes on to the counties, and it's the state responsibility to fund it adequately. So, it's really at their feet to make these systems work and make them more fair, I think. But yeah, when they fund indigent defense, it's sort of like, oh, that makes sense. At least it's not going to forensic testing or autism labs, which, I mean, it really goes to, the money goes to kind of weird things that are completely unrelated to indigent defense sometimes. So yeah, like I said, it cuts both ways. Like, I guess that's better that it's keeping it in this area, but it's also like defenders should have nothing to do with these fees and their clients, I think.
Elisa, go ahead.
Thank you. And thank you for doing this research. Most of my work has been in Florida and in the misdemeanor courts. And my understanding is in Florida, we're one of the few states that does not permit judicial waiver of these kinds of costs. And we're also in the application fees. So we require people. And when I first started doing this research 10 years ago, my students were shocked when they would go into court and observe, and they came back and they're like, Dr. Smith, they're charging people $50 to prove that they're too poor to hire a lawyer. And they just were like, they just couldn't understand it. And nothing has changed in the last 10 years. That's still the case. And then they add on more fees. My question, and I don't know the answer to this in Florida or elsewhere, is do you know whether these costs, like so many of the other fees and fines, are being charged late fees when people don't pay them, or they're accumulating interest, so that this $50 fee or $150 in costs actually begins to balloon? Because I'm seeing that with other fees and fines in Florida.
That definitely happens. When you're putting these like payment plans and you don't make your minimum payment or whatever you'll get either you get a bench warrant for your arrest, or you'll get some new punishment added on. So yes, it can extend the amount of the payment. There's a really good table in the report that's from the Iowa Legal Aid. Did really good information, has really good information on the collection pieces. And they also did an example of real life cases where somebody who is facing a certain particular type of case, who has the ability to hire counsel, and then somebody who has appointed counsel, they end up paying more. The person with appointed counsel ends up paying much more, other than for that attorney fee, through court costs and fees and fines. And so, yeah, no, that you definitely can mushroom, and that's what keeps you sometimes paying this stuff off until you die. I'm not exaggerating. That's what they say. Like in Nevada and Oklahoma, you have these things until you pay them off or you die. So there's some effort. Some of the reform efforts are just to have a sunset period. It can't be more than 36 months, or I don't know, maybe it's 4 years, 5 years, but like there has to be an end to this, because it just keeps going and going and going. Yeah, Florida's really, that's really terrible. It is one of the, maybe that is one that could be addressed through litigation, because I just don't think that's not an ability to pay determination. Anybody else?
On that,
Sorry, Torrin. Yeah.
no, go ahead.
I mean, I would just encourage, a lot of it's a combination of researchers and practitioners on the call. And honestly, I think there's like a huge awareness gap around this. That's one of the things that if we all just like went and sat in court and saw what happened, look at the report, see what the system is in your state, go sit in court and see what happens. I think that would be like really interesting. And if people just are more informed about it, they're in a better position, obviously, to say, hey, this is something of concern, when they're, in conversations with others who might have the ability to address this, or talk to advocates in their state, that type of thing. So, yeah.
Go ahead, John.
Hey, thanks so much. Hey, y'all, I'm John Irvin. Not actually a practicing attorney myself, but I work with an organization called Justice Text, to build software for public defenders. So thanks so much for putting this report together. I was struck by a lot of things, but really struck by the human consequence in particular. I'm talking about like the consequence of extended parole, work restrictions, license restrictions, things you can't do because you're trapped by these fees. And just hearing you mention spreading awareness, I'm curious if, as you're thinking about next steps, if there's space to illuminate some of the human stories that you and your team have pulled together of like what this means, not from like this is so obviously wrong from a legal perspective and practice perspective, but like, what does the $50 mean for like the human caught in the system?
Well, yeah, I mean, thank you, John. I think that as I alluded to in the kind of the next steps thing, like that's definitely a piece of research that has not been done adequately. And I think that you need to hear from people how this is affecting them. That's hugely important. Because again, I don't think like legislators and others, they have no really idea that this is even happening. And if they did, and if the media helped out, if the community knew more about it, I just think that they would be more outraged and more, willing to say, let's make a more sensible solutions here. So we definitely need more of that. Again, it's a next step of the research that we weren't able to get to with, doing stuff during the pandemic. We have some impacted people sort of stories, but I just don't think it's enough. Like, I think we need more. We can do some. I'm happy to talk to anybody who is interested in this, because I think that there are ways to go at it and to get support from others who are involved in these spaces. So yeah, absolutely. Well, Torrent, I don't know if anybody has anything else they want to talk about, or if
Yeah, definitely open floor. I feel like there's like a minimum like 30 seconds, and then before some people are willing to speak. Yeah, see. So Katrine asks, what do you think are the key questions to ask when surveying courts about indigency procedures and fees?
Well, yeah, thank you for that question. Key questions to ask are definitely around standardization. Like, how do they do it? What are they relying on to do this? Is it just like their opinion? Like, there was a judge in Oklahoma who said to a guy who drove to the court in a pickup truck that he used for work, he's like, your truck is nicer than mine. You don't need counsel. I mean, come on. Yeah, so it has to be some sort of standardization. I really think that it should be in a, I guess, Andy, you told us that they're doing this in Dallas-Fort Worth, where it is actually a real living cost of living sort of assessment that goes into it, as opposed to the federal poverty level, 125%, 200%, 300%, whatever it is. I just don't think that really takes into account actual cost of living. So when you're both determining indigency eligibility and when you're assessing ability to pay, it just needs to be much more, I think, routinized, or guidance needs to be issued to judges. So ask them, how are they making these determinations? I guess is one of the questions. Yeah, it's important. Yeah.
Go ahead, Eric.
The Vera Institute has an online assessment tool where you plug in numbers, and it's for ability to pay bail. But when I looked at it, I clearly saw you could tweak it to make it ability to pay attorney. So that's something y'all might want to check out, just as a solution to some of these problems.
Fines and Fees Justice Center has an ability to pay calculator for fees too, fines and fees. So yes, there are tools like that. They're great to look at.
Is anyone like, do you know of jurisdictions that are like using that as a matter of course, or is it just kind of like maybe a judge decides that that's what they're going to use, but maybe not
Yeah.
even that?
I don't know about the fines and fees Justice Center's tool. I mean, Andy can speak to, I don't know if he's still on.
Right,
but,
yes, they have their own, they're
um,
kind of internally developed tool, right?
Well, they actually apply it in Dallas-Fort Worth area. And so, yeah, like, how did they get that? I guess the question would be, how did that even happen? That the answer to that, because it's so important, it makes such a big difference. Maybe people can be assessed fines and fees, but not if they can't afford it. Really, that's what it comes down to. If they're going to have them.
What we find in Louisiana is if you're convicted, you probably aren't going to end up generating the $45 that we're supposed to get because you're going to get probated to death with all those fees, and just never happens. But what's weird about Louisiana is they consider traffic fines. If you pay that fine, you are convicted, you are pleading guilty, and we get money for that. And that's about, I think it's 49% of all the local funding that comes into our system comes from traffic, which I'm not advocating for this system, but at least those are people that, for the most part, or at least you're taxing some of the middle class with that, who don't need to, they present no burden on our system, which is, so that's kind of gravy money. And the $45 fee that you get if a guilty client actually pays it, you lost. You totally lost money because it costs way more than $45 to handle that case. So it's a strange sort of double-edged problem we have.
Yeah, I mean, I think that the, statement that you can't afford an attorney and then to say like, but we're going to make you try to pay for an attorney is just one of those things, and I think in general, like you really don't, there is definitely a conflict when fines and fees help pay for courts, and I think that is something that judges probably feel pressure for. And so I think it's just decoupling that is important anywhere we can, because just in general, it doesn't, like you're not making determinations based on things that you should be making determinations on. I think, it's just doesn't make sense in a lot of ways.
It's the worst possible way to fund anything is by picking the poorest people. And
oh yeah,
I mean,
Go ahead, Michael.
You hear me okay?
Yep.
I had a quick question. So Marion County in Indianapolis, Indiana, they often use a third-party collector to start collecting fees, fines, costs, including the public defender fees. And I wonder if any of the research that you've all done so far has found that to be prevalent around the country or not, where they sell the debt to a third-party collection entity.
Yeah, so I haven't studied like how prevalent that is, but that's definitely, I think that the courts often set up in a number of states where the courts make an effort for a certain period of time, or probation makes an effort for a certain period of time, and that then they pass it off to a contractor who's been asked to do that. And so yeah, what was probably an example of? Oh yeah, so Iowa, they don't have a mechanism really in the courts to collect stuff, so it all has to be offset to the private collection agency. So or the prosecutor has an option to be the person who's going to go after it and enforce it. So it's just it's just a nutty system. I don't know why any court would want to be in the business of doing this, but they actually in Oklahoma, they pay for staff who are charged just with that, just going after court fee. Like they run the cost dockets and they're the cost administrators. They set up the payment plans, and then they actually bug people during the pandemic when people got their supplement checks or stimulus checks. The courts in some counties apparently were calling people and saying, "Look, we know you got that check, and you need to send it in, send in your fines because we know you have the money now." It's just just all kinds of wrong.
Do either of you know, if the court sells it, does it kind of lose special status? Does it become dischargeable via bankruptcy like a normal debt, or?
It's all state by state. Sometimes it's civil, sometimes it's criminal. There's complications around bankruptcy that I fully don't understand, so I can't speak to that, but there are issues, yes.
I did do some bankruptcy back in the day, and you know, why would the law change? The bankruptcy law changed in Indiana. It was still considered non-dischargeable debt, like child support and student loan debt, that kind of thing. If they filed the notice of claim before your first hearing, they would usually file that, identify it as such, because often it would show up in a credit report as just a third party would know what it was for, and then they would file a notice of claim in the bankruptcy court, and then they would find that non-dischargeable. We also have a unique experience in Marion County, which is where Indianapolis is located, that we were sort of, the county worked out an arrangement that we as public defenders were required to try to help collect the initial, the $50 assessment fee that was imposed at the beginning. And many of us refused to do it because it put us in a weird position to essentially advocate against our client if they hadn't paid, like report to the court that they didn't comply with the court order voluntarily without. And we've gone around with at least one legislator who just felt that we were taking a bad position on that. Although some public defenders were comfortable with it, most were not, being the one to, chase the client down for the money and then report to the court whether they had paid it or not every time they appeared in court.
Yeah, I mean, I'll add on to that example. Like it's really sticky. So in some courts, it's up to the judge to determine at the time of sentencing how much you're going to pay. And if you're standing there next to your attorney, the judge will say, Judge, Attorney Adams, how much time did you put into this? And they oftentimes don't want to burden their client with too much money, but at the same time, they have to be, honest to the court in order to get paid. And so they're caught in this bind. And so if they lowball it, you can lowball it easier if you're a public defender than if you're a private court appointed attorney, of course, because you're still going to get a salary. But if you lowball it and then your client may very turn to you and say, you spent 3 hours on my case, and well, what do you think? It's just like it's an inherent conflict between your client and your own financial. It just is. It's obvious that it's a rotten system. So that happens around states.
We have one extra wrinkle in Louisiana that the court costs are divvied up amongst a number of entities: the DAs, the judges, clerks, some victim advocacy association, a couple of crime labs, a number of different people each get a little bite out of these court costs. And what the DAs have discovered is they can divert the case for a fee and take the whole fee. So a lot of entities who are actually, even though it's a conflict, we're reliant on those funds, the money we're getting is going continuously down. Do y'all have that anywhere out there?
I've not heard of such a thing. Yeah.
Another first for Louisiana.
And there's a comment or a question.
Yeah.
Okay.
So I was just waiting to no problem at all. So one quick one, Katrine linked the Washington tool that is like a legal financial obligation calculator. So Washington State has a system, but they state that few judges use it. So that's unfortunate. But Nathan has a very good topic for discussion. I'll briefly paraphrase, but basically that in Texas, it seems that judges use these fees as a trial tax. So they won't assess the attorney costs if the person pleads out, but that if it goes to trial, then they have to pay the lawyer a lot more. And so then they do assess those fees because it's costing them a lot of money. So this is something that he doesn't have data on, but just something that he's noted. So has anyone else noticed this or got it? I assume this can't be policy anywhere, but maybe I'm wrong and maybe the depths are lower than I think. But yeah, has anyone else noticed that or run into that as an issue?
Can I actually, Torin, could I call on Elisa Smith directly? Because I recollect your finding in Florida, Elisa, that there was a policy of you can pay $50 as an application, but it goes to $350 if you proceed past the first appearance. Isn't that exactly what we're talking about?
Yeah, there was one judge in Florida who did that. I don't think it was a policy across the board, but there was a judge who actually in writing said, if you plea at arraignment, it'll be this amount of money. If you plea or go to trial later, it'll be exponentially more. And again, nobody's challenging the legality of that. And so that was the case there. I think the bigger question is that I think a lot of people just aren't going to trial. So it's probably not even a trial tax as much as it is people are just resolving these cases to avoid any more accumulation of fees, even if it's a small amount of fees or a large amount of fees. But yeah.
One thing that we saw in some states apparently happening, like anecdotally, was if prosecutors would be willing to divert cases or give you a much better deal if you were willing to pay all the fees. So another approach we saw.
Leanne from Washington notes, I've experienced it when the client is acquitted, but not when they're convicted. To me, that reads like they punish the person for going to trial and then being acquitted. Because if that's the case, that seems even more backwards. Am I reading that right, Leanne, or is it the opposite?
Yeah, that was actually my experience when I was a public defender in California, that they would assess, I think it was maybe like $700 or $800 if the client was acquitted.
See, you got good representation. You got to pay for it, man.
Yeah. You get what you pay for.
The other thing is like, when you assess fees and fines on someone who's now going to go to prison for a long time. Like, I mean, there's a whole craziness with that where they attach to your prison. Anyway, sorry, Leanne, I didn't mean to cut you off, but it's like, it's just the craziness is, I mean, just compounds and compounds. On that note.
No.
Sorry.
Yeah, that would be a good note to end on, but we do have a few minutes if people have other topics. That is, I mean, in some sense, it makes sense that, like a person going to prison is not going to be able to pay, but man, that does just seem punitive, like
So
in
you
a completely backwards way. Say that again, sorry.
Want to hear another one in that
Yeah.
category? So people in Oklahoma, they get assessed costs of being in prison, not just jail. So they get assessed cost of jail, then they get assessed cost for being in prison, and they don't know what they're going to pay for a while after they're released, because they've got to calculate all these fees. So then they have to come back and they're put into this process, a Rule 8 hearing, which is the form or the process, the section of the law that relates to. And they are going to be put on a payment plan to pay that back, plus any other fines and fees. And so then, what, they go onto those cost dockets that I talked about earlier, and this whole thing starts, and they can very well be tripped up if they fail to make a payment for that, and maybe end up back in jail or prison. I mean, it's just pernicious. Never ends.
Are they actually trying to assess literally the cost it was to put them in prison? Or so
Yep.
so I assume the DOC has zero funding. They're a no cost agency then, right?
No, because people really can't pay it. Who can possibly afford that? So then they do. Another problem is, like, you don't really have attorneys involved in the Rule 8 process because their time of counsel has ended. There are a couple of advocates in Oklahoma that are doing that. They're specifically handling cases post adjudication and post prison to connect to amass a database and to represent individuals so that they can get at this issue and shine a spotlight on it, because it's a big problem for people.
If I could just bring up one other big problem, and I know this is Florida and elsewhere, is that the record keeping. So not only for data purposes, but the record keeping is slipshod. And so these people are paying and paying and their debts are accumulating, but nobody's really keeping good records. And in Florida, at least with felonies, they're not entitled to vote unless they pay all their fees and fines. And so there's not good record keeping. And these are individuals who aren't also keeping records. And I've heard of cases where people have overpaid, not knowing because they just keep making payments long after they fully paid their fees and fines. And it is pernicious, and it's a huge problem with very little oversight, as you point out.
That's incredible. I mean, it's just like example after example like that of just like, it's just mean, it's just like it's intended to punish people for being the wrong kind of people, I guess, it's just really awful.
Yeah, you just even being accused, right? Like it's an being accused punishment, right? In addition to, all the other stuff. Well, so we're right at 1 o'clock. So I think we can adjourn for now. But hopefully we can continue this conversation locally and on the listserv. Thank you again, Marea, for introducing us and kind of being the springboard for a lot of this stuff. And thank you all for coming. Thanks to the Decent Center for hosting. Thank you for my fellow IDRA board members for helping run this. But I think that's everything, and we can adjourn.
Thanks.
Thank you all.
Thank you.